Hello students, welcome to Byju's IAS. Welcome to a session on Explained, and in this particular video, we'll have a quick discussion on the concept of a GST council which was there in the newspaper very recently, rationalization of the GST rates, and finally the GST anti-profiteering law. Let me start with the first one, that is GST council. Please understand, with the implementation of the goods and services tax, the government of India, or to be more precise, the government as well as the states, inserted a provision under the Article 279, that is Article 279A, which basically led to setting up of a GST council. So in essence, the GST council is a constitutional body which has been set up by the President of India. Second point, the composition of GST council. It will consist of a representation from the central government, representation from all the states, as well as the representation from Puducherry as well as New Delhi. Third, whenever the GST council will meet, it has to take a decision on the resolution either through consensus or through voting. Now, whenever there is a consensus, it basically means all the member parties or all the members of GST council are in agreement with respect to this particular resolution. But let's say one or two states or even the central government is against one of the provisions of a resolution. In this particular scenario, there will be a voting which will take place. Now, please understand, whenever the voting takes place, the weightage of the vote will be distributed between the center as well as the states. Out of the total 100% weightage of the votes, 33.33% weightage will be given to the central government, and remaining 66.67% in totality will be given to the states. Now please remember this, the number of states will be 29 plus 2, that is one Puducherry as well as the other one New Delhi. So totally 31 members, amongst whom the total weightage of votes will be 66.67. In simple terms, per member out of this particular 31 member group, per member voting weight will be around 2.15%. Now, when I am discussing totality or in detail about this particular voting weightage, very recently in some of the states the elections have happened. Earlier the scenario was the central government used to have 33.33% weight, and the BJP government or BJP party formed the government in 16 states, and there were 4 allies which formed the government in 4 states. In totality, 20 state governments were either ruled by BJP or by an ally of a BJP. So in totality, here is 33% and here it will be more than 43%. In totality, BJP would muster or could muster 75.33% of the weightage of the votes. Why this particular number is important? Remember this, whenever the GST council has to take a decision through voting, the minimum weightage of votes which are required in favor of a resolution will be 75%. So earlier the BJP party or the BJP had sufficient votes to get any of the resolutions passed through GST council. But with the recent changes in the state governments because of the elections, 3 of the state governments are formed by Congress party now. As a result of this, now it will be slightly difficult for the BJP or the NDA at the center to get any of the resolutions passed very quickly or without any problems in the GST council, because it has to either seek the support of the Congress party or it has to seek the support from other parties which are formed the state governments in other states. So this is one very important point with respect to GST council. Secondly, very recently the GST rate rationalization has been done by the GST council. Now please understand, GST slabs in case of India are 0%, 5%, 12%, 18% and 28%. So as of now, the goods or the items which are covered under the GST have been distributed or have been placed under these particular slabs. Again, having said so, remember this, there is another slab, that is 28% plus cess. But over a period, the GST council has met around 4 times and has rationalized the GST structure. Now, the rationalization term will include two types. One, rationalizing slabs or rationalizing the distribution of the items. As of now, we have not seen any kind of a rationalization in the slabs. But very recently, the finance minister has stated that the 12% as well as the 18% slab will be merged, and it is expected, again underline the term expected, that the resultant slab will be around 15%. But as of now, there has been no kind of a rationalization in terms of a slab. But with introduction of GST, over a period of time, the GST Council has definitely rationalized the items being distributed or kept under various slabs. Over a period of time, many of the goods which have been kept under the 28% slab has been taken and has been shifted to either 18%, 12%, so on and so forth. And not only this, even the goods which have been kept under the slab rate of either 12% or 18% have been taken and have been shifted to different slab rates. This has been done in order to reduce the impact of the GST rates on a common man. As of now, within the 28% slab rate, we have got either luxury goods or sin goods, and finally one common good which has been kept even today under the 28% slab is the cement. But very recently, the government of India has stated that even the cement will be shifted to the lower slab. But please understand, having said so, the shifting will not be very easy for the government because it has got two concerns. One, usually we have seen that the cement prices are cartelized. That is, the cement manufacturers will come together and they abruptly vary the prices to make more profits from the market. So there is a cartelization in the cement industry. The government is worried that though it will reduce the GST rates on the cement and it will shift to, let's say, 18% slab rate, the manufacturers of the cement will not transfer all the benefit of this particular reduction in the tax in the form of a market prices. They may reduce the prices by a very small margin. And please understand this, one of the largest consumers of this particular cement in the market is the government itself. So the government on one side is worried about the reduction in the prices, whether it will be transferred or not. And second, it is worried about the loss of revenues. If at all cement is shifted from 28% slab rate to 18% slab rate, it is expected that the government of India will lose a revenue of around 13,000 crore rupees in the form of a GST revenues. Precisely because of these two reasons, the cement, though a common consumption good, has been kept under the 28% slab rate. The third point I want to discuss in this particular video is related to anti-profiteering. Please understand, there is a difference between the term profit as well as profiteering. Profit in simple terms is nothing but the excess of revenues earned by a company compared to its expenditure incurred. Whereas profiteering is nothing but unethical and unreasonable excessive profits earned. I'll repeat the statement. Profiteering is unethical and unreasonable excessive profits earned. This is called as profiteering. The mantra of GST is you are allowed to earn profits under GST, but you are not allowed to profiteer under GST. Now, what do you mean by this particular statement? Let's say hypothetically, there is a product X. The price before the GST tax rate is, let's say, 100 rupees. And earlier, the tax rate was, let's say, 20%. So the market price will be how much? 100 rupees plus 20% of 100 will be 20 rupees. So finally, the market price will be 120 rupees. Now let's say hypothetically, Government of India brings this particular product X under the 12% slab rate, as a result of which, rather than 20% tax, right now the tax which will be applicable will be 12% of 100 rupees, that will be 12 rupees. So the market price should automatically come down to 112 rupees. Now what if this particular manufacturer, with introduction of GST and this particular product being brought under the 12% slab, reduces the price by 1 rupee or reduces the price by 2 rupee? In simple terms, anything excess or above 112 rupees will simply mean that he is profiteering. In simple terms, the complete benefit of a GST reduction or GST tax rate reduction is not being transferred to the consumers in the market. This is the basic concept of a GST anti-profiteering. Now, what the Government of India or the GST Council has done? They have basically amended the GST Act and has introduced the concept of a GST anti-profiteering, under which an authority, that is National Anti-Profiteering Authority, will be set up. This particular National Anti-Profiteering Authority will have a composition of 1+4, that is 1 chairman, 4 members, and will have a sunset clause of 2 years. What do you mean by sunset clause of 2 years? It basically means once the authority comes into place, after 2 years, automatically the authority will cease to exist. That is the concept of a sunset clause. Remember this? Though Government of India or the GST Council has given the sunset clause of 2 years, the earlier CEA, Chief Economic Advisor, had recommended that the sunset clause for National Anti-Profiteering Authority should be for 9 months. Now, what is the role of this particular authority? The role is to ensure that there is a commensurate reduction in the market prices with reduction in the GST tax rates. I'll repeat the statement. The role of Anti-Profiteering Authority is to ensure that there is a commensurate rate reduction with reduction in the GST rates. But please understand, this particular document or the guidelines which have been issued by the authority do not define what do they mean by commensurate reduction. Very recently, this particular terminology or the GST anti-profiteering was there in the news because the National Anti-Profiteering Authority has fined more than 300 crore rupees of a fine or worth of fine on the Hindustan Unilever Limited company. The argument which has been put forward by this particular authority is that with the reduction in the tax rate, this particular company did not pass on the benefit to the consumer. On the other side, the HUL has countered this particular argument, stating that 1. The way that the authority has calculated the profiteering is not based on any kind of a standard formula, and second, HUL earlier had already increased the grammage. That is, rather than reducing the prices with reduction in the GST rates, the company HUL had basically stated that the content or the grams of the goods which will be provided will be increased. This was the stand taken by HUL earlier, and despite the authority imposing a hefty fine on HUL has stated that they will take the legal recourse which is present under the Anti-Profiteering Authority to counter this particular fine imposed by the National Anti-Profiteering Authority. So this is under the discussion with respect to the GST in the recent times. So these are some of the points which have been there in the newspapers with relation to the GST Council, GST rate rationalization, as well as GST anti-profiteering. Thank you. Have a good day.